Dear students, warm greetings to you all. Today we will focus on the most important part of our civil procedure, that is settlement of disputes outside the court. We will recollect the famous quote by Abraham Lincoln: discourage litigation, persuade your neighbors to compromise whenever you can. As a peacemaker, the lawyer has superior opportunity of being a good man. There will still be business enough. In this instance, it would be appropriate to look into the endeavor of an element of settlement of disputes in epic ages. In Ramayana, Lord Rama sent Angada to court of Ravana as a diplomatic messenger to warn the Lankan king to set Sita free and avert a destructive war. In Mahabharata, Dhritarashtra sent a Sanjaya as a peace messenger requesting peace but not offering any kingdom. Then Krishna himself went as a peace messenger. It understands us the importance to avert the dispute. The efforts made by both ages were not successful. Coming to the present topic, Section 89 of CPC provides for settlement of disputes outside the court. The provisions of this section are based on the recommendations made by the Law Commission of India and Justice Malmath Committee. A litigant is free to settle his dispute on a reference made by the court by resorting to any of the modes like arbitration, conciliation, judicial settlement, including settlement through Lok Adalat or mediation. It seems that special provision has been introduced in order to help the litigant to settle his dispute outside the court instead of going through the elaborate process in the court trial. You all might have observed during your internship the application of this settlement outside the court. These alternative means were recognized not only in India but also in the parts of the world. Thus, the settlement of disputes outside the scope of the formal legal system may be called alternative dispute resolution. Now, we will understand the scope, applicability, and the need for ADR under the provisions of Code of Civil Procedure. This section 89 provides that where it appears to the court that there exist elements of a settlement that may be acceptable to the parties, the court shall formulate the terms of settlement and give them to the parties for their observations, and after receiving the observation, the court may formulate the terms of possible settlement and refer the same for arbitration, conciliation, judicial settlement, including settlement through Lok Adalat and mediation. The section provides that where the dispute is referred to arbitration or conciliation, the provisions of Arbitration and Conciliation Act 1996 would apply. Where referred to Lok Adalat, the relevant provisions of Legal Services Authority Act 1987 would apply. In case it is referred to mediation, the court shall effect a compromise between the parties and shall follow such procedure as may be prescribed. It is, however, not clear from the provisions of Section 89 where the reference by the court to the alternative method of dispute resolution mechanism is mandatory or directory. It also does not suggest the stage for such a reference. Now we will understand about judicial interpretation. In Salem Advocate Bar Association versus Union of India, A. 2003, SC 189, the Supreme Court held that the provisions embodied under Section 89 do not suffer from constitutional infirmity. In this matter, the apex court formulated the civil procedure, alternative dispute resolution, and civil procedure mediation rules 2005. The court directed to be adopted by the respective high courts in civil rules of practice and circular orders. As we know, while studying some sections, we have relied on the relevant orders contained in the CPC. The provisions of Order 10 confer on the court a power to examine parties with a view to ascertain the real points in the controversy between them and to get admissions from them with a view to eliminating irrelevant issues and evidence, thereby shorten the trial. This rule relates only to the ascertainment by statements of the parties themselves or their pleaders, whether allegations in the pleadings which were admitted or denied by them. Such ascertainment is to be made when the allegations are not expressly or impliedly admitted or denied by the party against whom they are made. Now, we will ascertain the expression used in the order, that is, first hearing. What does this expression mean? The expression has not been defined in the code. It is the day on which the court proposes or purposes to apply its mind to determine the points in the controversy between the parties to the suit and to frame issues if necessary. It is the day the court which applied its mind and goes into the pleadings of the parties in order to understand their contentions. After recording admissions and denials, the court shall direct the parties to settle the matter out of court and to adopt the modes embodied in section 89 of code, that is arbitration, conciliation, mediation or lok adalat. The next important component of our topic is judicial aspects in section 89 of civil procedure code. In the matter B.S. Krishnamurthy and another versus B.S. Nagaraj and others, A. 2011, SC 794, Honorable Justice Markandeya Kaju and Honorable Justice Gyan Shudha Mishra opined that an effort should be made to resolve the dispute between the parties by mediation. The court referred to quote the passage from Mahatma Gandhi's book, My Experiments with Truth. My joy was boundless. I have learnt the experience and practice of law. I have learned to find out the better side of human nature and to enter man's hearts. I realized that true function of a lawyer was to unite parties riven as under. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. The Honorable Bench held that lawyers should advise their clients to try for mediation for resolving the disputes, especially where relationships like family relationships, business relationships are involved. Otherwise, the litigation drags on for years and decades, often ruining both the parties. Hence, lawyers as well as litigants should follow Mahatma Gandhi's advice in the matter and try for arbitration or mediation. This is also the purpose of section 89 of the Code of Civil Procedure. Next, we can concentrate on refund of court fees. Now, the question arises, if the parties settle the matter outside the court, what about the court fees paid at the filing of the suit? Recently, the Supreme Court of India held it is permissible even in cases in which parties, without any reference by the court, privately agree to settle their outside modes of contemplated under section 89 of CPC, and such settlement is legally arrived at. Last but not least, it is necessary to inculcate and expand the culture of alternative dispute resolution. The International Center for Alternative Dispute Resolution, that is ICADR, mentioned in its objects as to expand, encourage, and popularize the scientific means for the settlement of local, national, and international commercial disputes, and also to provide assistance and render facilities for arbitration, conciliation, and mediation. With this, I hope all of you understood each and every point regarding the power of the court to refer the matter to settle the matter outside the court as discretionary and obligatory power. Next time, we will observe the other interesting principle contained in the Code of Civil Procedure. Thank you to all. I will see you then.